Good morning, everyone. It's a pleasure to welcome you all to today's webinar, the title being Fast Tracking Mergers and Acquisition Approvals and the NCLT. This webinar is part of DAKSH's Transforming Tribunal series. My name is Ritima, and I'm a lawyer, research associate at DAKSH. I'll be moderating today's session, and our goal is to ensure an insightful and engaging session where we delve into critical issues of mergers and acquisition. So, setting the context and the tone for the webinar, we are at a critical juncture in India's economic and regulatory landscape. Mergers and acquisition have long been powerful tools for corporate growth, restructuring, and market expansion. But ask any industry expert, including the panelists here, they will tell you the process of getting a deal to a finish line is anything but fast or time-bound. And the National Company Law Tribunal, NCLT, remains a key gatekeeper, but its process often lead to delays, creating bottlenecks that frustrates the businesses and the investors alike. Now, the government has finally taken note of this, and during the Union Budget 25, bold reforms have been proposed to cut through the red tape and make mergers and acquisition more efficient. But does this Actually, what does this mean in practice? Will bypassing the NCLT for certain mergers lead to faster deals? Or will it open floodgates to risk and uncertainty? How will the regulators like CCI step up to balance the speed and oversight? And most importantly, India needs this shift, but is it ready for it? So these are the burning questions we will tackle today, and we have an exceptional panel of experts to break it down for us. Our first speaker will be Mr. Vardaan Ahluwalia. Sir is a General Counsel at Premji Invest, a top legal mind in private equity and mergers and acquisition. Followed by him will be A. Murli. Sir is an advocate, a sharp and a seasoned litigator who has worked extensively on corporate disputes and mergers and acquisition. We have Dr. Shouvik Guha. Sir is an associate professor at NUJS, an academic powerhouse who has studied and analyzed the legal frameworks shaping India's business landscape. Before we dive in, we have quick housekeeping rules. First, if you wish to, for all of the attendees, if you wish to ask any question during the session, please use the raise hand icon and our team will unmute your mic. You can also post your questions on the Q&A on the chat box, and during the Q&A session, that is towards the end of the webinar, we'll post your questions to the speaker. And we hope for a lively and thought-provoking discussion. With that, I invite Mr. Surya Prakash, he's Program Director at DAKSH, to share the vision of this webinar series and the project, followed by the first speaker, Mr. Vardaan Ahluwalia, sharing his thoughts. Over to you, sir.
Thanks, Ritima. Thanks, Vardaan, Shouvik, and Murli, who will be joining us very soon. Very quickly, DAKSH has worked on judicial reforms for some time now. And we have seen very closely what is it that is broken and what it takes to fix it. But we have felt over all these interactions with the industry, with the government, with the judiciary, that somewhere tribunals are not included in this discourse on judicial reforms. Tribunals are unique creatures, if I may call it that. They are a mix of the executive and the judiciary. And they handle very important matters that concern the economy, the business, privacy, tax. All of these big ticket items are actually handled by tribunals before they end up in courts. And tribunals, being under the control of the government, really should be of a much higher standard than courts, because tribunals, if you look at it, were set up with the vision that they are going to help in reducing the time taken for disputes, the quality of resolution, etc. We are far from it, and DAKSH has looked at it in the past, whether it's the paper on National Tribunal Commission or the Coalition for GST Appellate Tribunal. We now believe it is time to step up and look at all commercial tribunals because they suffer from common structural and capacity issues. This is the first in a series over the next few months, you will find many other such conversations. I'm thankful for the panelists for sparing time to join us today. And without much ado, asking Vardaan to start with his comments. Thank you.
Thanks, Surya. Thank you to everyone who's taken the time out on a Saturday to join. Just sort of introduce what Premji Invest is doing with DAKSH. We are completely aligned with what Surya says that, if India's ease of doing business has to improve, and if we are to be a destination which sort of is competing for foreign investment and would become an attractive destination for foreign investment, or even for domestic players to deploy capital with certainty of outcome. There are various pieces which need to be resolved, and one of them definitely is the justice and the dispute resolution system, and within that the tribunal system, since a lot of commercial disputes today under various legislations are governed by tribunals or some sort of a quasi-judicial body. Now, whether it is competition, whether it is companies law, whether it is tax, you look at GST, all of this is in one way or the other feeding through quasi-judicial bodies and then getting into the judiciary. So a lot of the disputes, especially for the SME, MSME sector, sort of go to these bodies, and which is why it is very important to kind of look at what these bodies are doing and how can they be improved to bring about ease of doing business in India. I think that's the background with which we decided to collaborate with DAKSH. As we speak, we are looking to put together a coalition to set up a study on tribunals in India, specifically for the NCLT and the NCLT. We hope to do an empirical study to understand what are the reasons why there is a backlog, and why is it that or what can be done or what should be done from a comparative perspective to see a positive change and to move things in the right direction. You have to pardon the background because I am at a busy place, could not avoid, but just bear with me, please. So that's the background, and which is why we feel that this is very important. And I'll give you a very simple illustration to kind of bring out the fact why this is so important to everything that you do as a commercial lawyer or as an investor. Assuming, and we'll come to fast tracking mergers, etc., but just to sort of explain how tribunals or how dispute resolution is so important. You sign a contract, right? Let's say it's an SHA, it's an investment agreement. Any clause in it that you want to, enforce for it to be meaningful, there has to be certainty that it can be enforced with the intent that it was entered into, and in a time-bound manner. If any of this is not there, if there is not certainty that it would be interpreted in the right way, if there is no certainty that it would be done in a certain amount of period of time, and which is reasonable, commercially reasonable, and that the cost would not be more than, let's say, the investment, can't be the investment value, but let's say not more than 1% of the investment value, you would see that it is then considered by business as a item that needs to be worked around. Then suddenly it becomes an obstacle, or it becomes a risk that needs to be factored into the investment. If I give you the flip side, that let's say you know that a clause can be enforced in 6 months, relief can be got within 9 months, right? And that the cost of that enforcement will not be greater than X amount, you would see a lot more certainty and greater, you would see reduction in notional transaction costs and greater and faster deal making. So that's the background how dispute resolution is looked at in India, and which is why we are so invested in this conversation. Now, coming specifically to fast tracking of mergers, I think it comes from, and why this conversation is relevant is because the finance minister in this year's budget specifically said that the government is looking to bring in reforms to enable mergers and to simplify the process. Now, today there are two separate categories, and I'll let Murli and Promik also speak on it. From an academic and a practicing counsel perspective, Murli being a senior lawyer who was in law firm practice and now is doing his counsel practice. There is the fast track and then there is the usual merger. The fast track comes with the sort of background that it's not very controversial. It's usually for a wholly owned subsidiary or a small company. And so therefore, it kind of, makes sense to have accelerated process as the chances of there being a dispute is lesser, and that the number of parties that may have an issue with it would be negligible. And so therefore, start with the RD, which is below the NCLT, so to speak, in that sense, as the officer who clears it. Your hearings also happen at the office of the RD. And then it sort of goes to the NCLT in case there is something that is amiss. It's a time-bound process today. So one could say, theoretically, if you look at it, that perfectly well, works very well, and that's fine. But what happens is, in practice, that in a country such as ours, there's a lot of legitimacy that a judicial process brings to a commercial transaction. And what I mean by that is that if I am, let's say, an investor who's doing a merger worth $500 million between me and my subsidiary, and if it were to get a fast track approval, right, wholly owned subsidiary, right, I would not be perhaps sometimes be comfortable that it is without the oversight of a judicial authority, or that I have to go through that the NCLT does not, so to speak, approve the scheme, right? So that is one piece, and that piece we need to sort of think about. And then the added piece is that if you then load the NCLT with too much, then you're again compromising the speed at which it happens. So I think the larger point that we need to think is whether we do fast track outside the NCLT or within the NCLT. One thing we need to agree is that the NCLT needs investment. It needs appropriate sort of structure to ensure that it is able to process these non-litigious or contentious matters in a time-bound manner. Now, the IBC did it really well in some ways. I mean, of course, the principle of 14 days was further diluted, etc. But because the statute spoke of a certain timeline, you had the NCLT sort of working along with it, and even parties sort of, endeavoring to ensure that those timelines in one way or the other are adhered to, or otherwise, if there are exceptions, which there were many, there is an explanation as to why that happened. So one, I think, point for us is that if we expand the scope of the fast track merger, we need to ensure that it continues to be a time-bound process. Second, we need to scale the NCLT. At least there would be consensus. I would think that this panel also can arrive at a consensus that there is needed scaling, and scaling can happen by way of just investing in the secretariat, investing in the benches, increasing the number. Perhaps technology and AI may, and that can be a field of study on its own, but how technology can be integrated to reduce these costs, that is one part that needs to be done. One also needs to think what else can be done. And this we see sometimes having, advising investment professionals. Many times it is not about the cost, or it is not about rather the process, it's about certainty. So let's say the government comes out with a scheme where it says that, okay, if you want a fast track, no matter what type of merger it is, you need to pay X amount of fees to ensure that it is done, right? That can be one way to ensure that people who really want it on a fast track, irrespective of whether it's a wholly owned subsidiary or not, that fees is paid, and then it's kind of a service that is given by the governance system, right, to them. That could be one way to think through that, where you ensure that at least the high value important mergers where they really want it to happen, they want deal certainty, etc., that happens. There are the procedural things, and or the other issues which need to be looked at in nitty-gritty to ensure that, because all the ducks, everything needs to be aligned before a reform that is introduced with the right intent from a policy perspective is actually able to make a difference. So, for instance, lender consents. The way I understand it is that you need to produce the lender consents before the relevant authority, right? In the case of a merger, the NCLT, for instance. Many feel that, or this is the industry feedback I get, that if a party is able to produce an affidavit saying that, I have received the lender consent, then why do I need to go and get it again and produce it before the tribunal? Why can it not be on my affidavit, right? So those are the kind of wrinkles also we need to think through and ensure that, overall you come up with a regime which is comparable to international standards, while it is bespoke enough that it, meets the requirements in India. But I would now, or at least now, I am starting to develop the view that India is not that unique, and business around the world is the same. Mergers around the world are the same, whether it is in India or in the US. Now we are a big enough, mature enough, robust commercial economy where we can start saying that Indian exceptionalism and rulemaking is not needed within India, and that we should start comparing ourselves with a Singapore or a Hong Kong, or a US or a UK, and see how they do things. Because people who come for these sort of transactions are people who are also dealing with Singapore, UK, US, right? So they immediately compare you with these jurisdictions. So I think the larger point that I'm trying to make is the conversation needs to elevate now I feel that within the ecosystem. It is not just about solving the specific issues within India, but actually comparing yourself by way of a comparative study. And it would be really good if the government comes out with it. Like they say that, okay, we've seen what happened in the US, in the UK, in Singapore, these jurisdictions, Dubai, for instance, not being a common law country, but at least with common law countries, that this is what happens there, this is the time they take, and our objective is to beat them or perhaps match. I think that is the place where we want the conversation to start with the government and with the regulators, that this is our aim and this is where we want to be. I think now I'd want to open it to the other panelists also as to what they feel and what specifically they've seen in their experience, and we can take the conversation forward.
Hello, Murli sir, if you can pitch in.
Yeah. Good morning, everyone. Thank you for having me in this panel. So, before starting, I'll just step back a little bit into the history and where we are from what we were. Having practiced this branch of law and dealt with for 40 years, I must share my experiences when the court process or mergers were in the under the domain of the High Court, the jurisdictional High Court. So we were the of course those days when court mergers were picking up, there weren't too many, not in the scale and volume what we see today, but nevertheless probably the high court itself sat for a week, once a week or maximum twice a week, and were able to take up these merger matters and dispose it off in 4 to 6 months. That was all it was taking. It was all time-bound process. I mean, the stage of ordering meetings or dispensation were all taken then and there. And there was, the court would look at your pleadings, see whether the creditors have consented, shareholders have consented, and then and there decide whether a meeting is required, not required, and then go on. Petitioners file, notices are issued to the Department of Company Affairs and the liquidator where it is a merger and not a demerger. And once their report is filed, the parties are called, the issues are argued then and there, and the High Court takes a decision. And in fact, many a important proposition of law has been laid down either by high courts or the Supreme Court those days with regard to the merger process, like the single window. This is one, you don't have to go to multiple places, or if it's a reduction of capital as part of a merger, one process is sufficient. Valuation is a domain of the expert. The department or anybody else should not come and interfere in that. If the stakeholders have by a majority approved, then the merit of the scheme is not open to scrutiny. And the proposition saying that the High Court is only like an umpire, it is not a player. It is to see that the game is fairly played and not to impose its view and say whether a better scheme is possible, and saying the commercial wisdom lies with the shareholders or the stakeholders rather, and it is not for the court to look into. So various such propositions of law have been laid down. So what I'm trying to say, it worked well. There was nothing very difficult. Even if it had gone to the scale of mergers which happen today, I'm sure it could have been dealt with the same level of efficiency. When the 2013 Act came and effectively most of these, even migrating the mergers, the process to the NCLT, we did have high hopes because you have jurisdictional NCLTs in every state and multiple benches, at least in the larger cities. Unfortunately, Bangalore, we are still struggling with one. And we did expect, thinking, yes, there is a judicial member, there is a technical member. This is what should I say, nuanced, specific thing, and we will have experts dealing with it, and it will be disposed. Matters would receive expert attention, and these things would be done in a quick manner. In the sense, we thought these things coming within the domain of the tribunal itself is a fast track. In the sense, High Court had its own limitations. Once a week, the judge's roster changes. Judge handling company matters for 3 months. Next, he will go. Another person will come. We have seen cases where a judge would come and say, I do not know company law, please educate me. He would take a week or so, quickly come up to speed and deal with these matters. So we had that fond hope when this NCLT came into place. But unfortunately, down the line, what has happened is the I don't know whether it flows from the ministry or wherever, the emphasis has been to deal with the IBC matters and not company law matters. this is big, this is taken a backseat, saying, oh, this is something routine, this can wait. The commercial exigencies, the need to complete a merger process within a financial year because it has its own importance, that has been completely lost sight of. This is a practical issue we are facing. And a simple thing like whether a meeting should be held or not, or a meeting has to be ordered, even to take a simple decision like that, multiple adjournments, and after hearing the matter, orders are not passed immediately, it is reserved, passed later. So for example, if you file an application, for what we call the first motion application, to decide whether a meeting has to be held or dispensed, for that to come up itself is taking 4 to 5 months, by which time in our earlier high court regime, the petition itself has reached its final stages. I'm talking about the practical difficulties we are facing. Of course, the Act also had carved this subset of fast track mergers within the jurisdiction of the administrative head of the region, the regional director. I must say that has worked fairly well. From what you have seen, it's a pure administrative process, not too many, because the person who has to file a report itself is sanctioning the scheme, and those are happening within 2 to 3 months. But as we all know, that is again restricted to what we call small companies and holding company subsidiary company merger. But there also we find certain what should I say, limitations, understanding law, judicial application of mine is not there, because after all they're administrative officers. I may cite an example. There was a merger of a subsidiary of a with a listed holding company. So this fast track merger talks about the 90% approval being obtained. So, of course, this was prior to the Bombay High Court decision, where it said in a holding company subsidiary company merger, it is sufficient if the subsidiary alone filed a petition and holding company need not. Nevertheless, in this case, the holding company also made the necessary application. As you are aware, in a fast track merger, you need not go to the authority, take permission to hold a meeting or dispense with. Straight away, either you hold the meeting or show that you have secured the consent of 90% and then file the application. Here, what happened is the holding listed company did hold meeting, and at the meeting, 90% majority, of course, in of those present and voting was secured. The regional director simply rejected it, saying it is not present and voting, but you should actually secure 90% majority of the holding company. Now, imagine a situation in a public listed company. Is it at all possible to go around and secure this 90% approval? So, in an earlier case, very strangely, in an earlier case, that regional director accepted based on some sound legal opinion, saying, yes, it is those present and voting, that is the law, and it need not be 90% of all the shareholders of the listed company. But a subsequent officer took a different rigid view, where time was lost and the company was forced to go to the NCLT for the same process. But luckily, by then the Bombay High Court decision was in place, which said a holding company need not file a petition. It is sufficient if this subsidiary alone did it. So there was some saving of time. So what is happening is they need to be educated. Okay, fast track, saying the regional director under the fast track process can also consider other than small companies and holding subsidiary companies mergers, demergers. We could add a few. For example, any company, regardless of if it's small or big, other than a public listed company, could be put in fast track, because after all, this, stakeholders are not too many. If it has to be, if the shareholders may be minimal, assuming it's an, even if it's an unlisted public company, We don't come across too many public companies unlisted having too many shareholders. So that is one part with you can invite objections and deal with it. But they have to be educated a little more to look at it. Who are the stakeholders to be protected? Of course, here the creditors. Ensure whether the creditors no objections have been secured and they can proceed. Of course, public listed companies come under a different category. It may not, if it is a regular merger involving a public listed company other than a subsidiary merger, but it requires some more judicial process. It can go to the NCLT. So perhaps in this fast track, what we should be looking at is, other than small companies and holding subsidiary companies, uh, perhaps listed companies, of course, and those kind of transactions or mergers, demergers, which also come within the scope of the controller of the Competition Commission, CCA, because they are large size, large ticket transactions. Perhaps that may not, it may not be right to put that at the doorstep of a regional director. It may be difficult to deal with. So fast track may help, because quite honestly, the fast track mergers have been happening much faster than the NCLT process. So, and also coming to the process, I think I have been talked to asked to speak a little bit about the regulatory legal challenges what we've been facing in the NCLT process. Apart from the notices to the regional director, you also have to send a notice to the official liquidator at the income tax department, and only when all their reports are in place, the court proceeds to consider. The court, what I mean by court is the tribunal, considers it and approves, or considers the scheme. So here again, we could do with some clarity as to what is expected of these authorities, what they should touch upon. For instance, it's a settled proposition of law, as I mentioned earlier. For example, valuation of shares. This is completely what should be the swap ratio. For example, it is the commercial wisdom of the shareholders based on a valuation obtained by an expert. In all these, we know it a swap ratio is determined by an expert. The law says either a firm of chartered accountants or a class 1 merchant banker. If the valuation has been given, it's an expert's valuation. And in the commercial wisdom, of course, in this, the only stakeholder concerned insofar as swap ratio is the shareholders of the two companies. And if they have accepted, it is not for any other regulator to go into and question the method of valuation. But we do very often come across situations where the regional director goes into whether the valuation is right, whether this method of valuation is to be considered or that should be considered. Definitely, it is not for him to comment upon. It is the commercial wisdom. All that, as a the MCA or Department of Affairs of the Department of Company Affairs, he has to see whether the company has been compliant with law, whether the scheme is in accordance with law. It does not, deviate from the accounting standards. He has to read the scheme and bring it to the notice of the court as to whether it is in compliance of law or whether it is against public policy. These kind of things again. So they should also be educated. Say, confine yourself to filing a report on what is required of you. After all, they are that report, the notice goes to them and they are called upon to file a report to assist the court, not to impose their own will and try to say whether the scheme is right or wrong. Likewise, even in the case of the official liquidator, in the case of a merger, the previous Companies Act very clearly said the report of the official liquidator is required, saying that the affairs of the transferor company have not been conducted in a manner prejudicial to the interests of the shareholders of the or the members. before the court can proceed to dissolve the company without winding up. Because you all know, in a merger, one company gets dissolved without following the procedure for winding up. So that is why the liquidator comes and says whether the transferor company has conducted its affairs in a manner, in such a manner that there is no difficulty in dissolving this company without winding up. So he goes into the books, sees there are no outstanding issues, and report that. We now come across cases where even the liquidator goes into valuation, the merit of the scheme. It is not for him to comment upon the merit of the scheme. He only has to go through the books of accounts of the transferor company for the last few years, satisfy himself that it has not been carried out in a manner prejudicial to the interests of the public or shareholders. There are no glaring, audit observations unaddressed or otherwise, and bring it to the notice of the court. In the end of the day, when you pass this order, this company is effaced, going out. So please look into and take a conscious decision, this company, whether it can be dissolved without winding up. So when the official liquidator also parallelly goes into the merit of the scheme, what is which is again the domain of his fellow department person who's the regional director. It duplicates things. Then they're working at cross purposes. uh, for instance, I had a recent experience where the Department of Company Affairs gave its no objection to the scheme. The liquidator vehemently opposed a particular, what should I say, a certain investment write-off, all done by the transferee company, with which he was not concerned at all. There was some, what should I say, large investments were made. Then the value came down. There was impairment. The impairment was written down. So suddenly he came out. This is all done by the transferee company. Not none of the transferor companies did any such thing. So when he enters into the domain of somebody else, it goes into a spin. Time is lost. Of course, eventually the tribunal held that there is nothing. It doesn't affect the shareholders or public. It is an internal thing. It was in accordance with the accounting standards and all that. But if the regulators overstep and do all these things, these can also cause considerable delays in the whole process. That's what I'm trying to say. So eventually, even this tribunals, they are also governed by the diktats of the same ministry. So the ministry can give out specific, clear guidelines and say what are your roles and responsibilities when notices go to these two arms, saying you confine yourself to these things. You help the court, assist the court, bring it to the knowledge. Then it is between the court and the petitioner as to what are the points to be addressed or otherwise. So in my mind, apart from saying what should be the company, who are the companies who should be within the fast track process, the as to what are the roles and responsibilities of the regulators who are involved. As a player, what is your role? So you confine yourself to your role. Don't overstep, because unlike a high court, you can't expect a tribunal to lay down law. They just go by what it is, eventually approve the scheme or not. Same way, the income tax department, it is routinely, at least one issue is addressed. They would say some tax recovery is pending, or assessment proceedings are pending. So because of that, scheme should not be approved, or unless the disputed tax amount is paid, the scheme should not be approved. But luckily, the appellate tribunal has said this merger process is not a tax recovery proceeding. It is for them to come and say whether there is an evasion or any, again, by approving the scheme, there is anything opposed to public policy. Saying that there are assessment proceedings, it it doesn't take you anywhere. Every company will have some pending tax proceedings. It will go on, and invariably all the schemes do provide that the tax proceedings pending against the transferor company will be dealt with by the transferee company. It will go on. So again, the income tax department also should be clearly told what is the scope, what are you supposed to report. Notice goes. We come across cases where 2-3 months they don't respond at all. They say, yes, I'm taking instructions. Finally, they say some appeal proceedings are pending, tax proceedings are pending. All these are again causing delays in final disposal. And by the time the process is over, the financial year gets over. And the same, the people who caused the delay come and say, the financial year is over, you please move the appointed date or the transfer date, without for a moment understanding how critical the transfer date is in all these schemes, because you want to consolidate as on a particular date. In many cases, these court mergers are simply they are a corollary to a larger M&A transaction. A transaction has happened. This is a vehicle, nothing. It is not that this itself is a transaction. An acquisition has happened, and to give effect to it, we have a merger process. And suddenly coming without understanding, saying that you shift the appointed date to something else, for which the parties, the companies concerned, are not at fault. The delay is on account of the process or on account of the regulators. So these are some of the aspects that the government has to be mindful and say, these are things where a regulator should not trample upon. They should be made to understand the commercial exigencies of all these court mergers. It is not a mere cleaning up thing, like somebody did mention earlier. These are all part of a larger M&A transaction. And likewise, many a global merger happens. The acquirer and the acquired, they all have companies in various jurisdictions, countries, and those are the kind of mergers we routinely see. Globally, A and B merged, so A and B have subsidiaries here. Simple. Those kind of mergers also should go and fast track, regardless of size. A global merger has happened. This is nothing but a housekeeping kind of merger. The parties are the same. They should also be treated. Even fellow subsidiaries merging should all come under fast track. It should not be unnecessarily left to this long-winded process. So again, this is one subset which should definitely come under fast track. And yeah, and coming back to the NCLT process, this is something we all speak with a lot of we are exasperated the way it has gone on year and a half. I mean, it has become very embarrassing to tell the client. Even first time when you meet, saying how long will this merger? I mean, we cringe when we say it takes any time between 12 months to a year. I'm being very candid on this platform. We've made representations. Of course, there is this talk of saying having a separate bench to deal with company matters, separating IBC and the company matters. Though it is called National Company Law Tribunal, it has actually become a National Insolvency Law Tribunal. They have dedicated 1 day per week for company law matters. That's hardly sufficient. These are all routine. And I mean, since I have this platform, I may say at least mergers are receiving some attention. These operation mismanagement cases have taken a complete backseat. There is total reluctance to take up and deal with these matters, because I don't know, because the ministry asked for statistics on IBC, how many resolution plans were approved, how many did you consider. If your mindset is to work like a department and not like a court, so we are missing something somewhere. So yes, the fast track, moving many of these things to fast, other than listed companies and these mergers not involving the competition commission may not be a bad idea, but at the same time, the ground rules must be laid out very clearly, and all the regulators, the authority must be told very clearly what you have to look into, what you are expected to do, so that we don't go around in circles. Because in many a case, it is more like a housekeeping, simple enough process. See that the shareholders and the creditors are protected, and if if it is what should I say, fraud in a scheme, or it's a tax evasion, the departments will certainly bring it. And there is a provision under the Companies Act. If there are contentious issues and the regional director cannot deal with it, he can always escalate it to the National Company Law, to the NCLT, jurisdiction NCLT, which is a quasi-judicial forum. To that extent, it is protected. Governance and those issues can be escalated there. So, yes, fast tracking is not a bad idea, provided the ground rules are laid, the regulators and the authority are told what as to within what rules you should operate and what is the end thing. Eventually, you have to expeditiously dispose of these matters because they have a direct impact on business, the revenue, the tax, everything. I mean, the tax planning, everything is linked to all these things. So, the importance of expediency in disposing of these matters must also be impressed upon. Subject to this, I would welcome this fast track project, moving a lot of it away from the NCLT domain and leaving it there, subject to the frame of the contours as to how they should operate. These are my thoughts. Thank you.
Thank you, sir. Ritma, I'll just come in here. If
Sure.
So, sir, what you say is very relevant in the sense that, we were thinking about like a single window clearance from regulators. But what specifically you've touched upon is quite important. For instance, when I'm getting an arbitration award to enforce into India, there are only very specific items basis which a court can intervene and set aside that award. Otherwise, it becomes a decree. I think something of that sort of that clarity, because that gives me certainty when I'm advising people internally or generally as such, that, these are the 4 or 5 grounds basis which something can be set aside. And if those kind of prescriptions can be given for the, various departments that, this is what you need to look into. If you have a comment on this, make it. Otherwise, don't just kind of generally sit in judgment over the commercials, is something that should be legislated and should be thought through. I think that is something very important. And now that we are seeing the intent from the government to kind of bring in some sort of reform, we should use the opportunity, Surya. We should definitely take this up to see how we can sort of put it together, collate it, and take it to the right people. The other, for instance, you touched upon IBC. Even in IBC, you would know that the court has recently said that before the creditors can approve a resolution plan, you please go get CCI approval. Now, anybody knows that, when I am doing a merger deal, first I have to kind of sign the document, put it together, and then after that I go for the procedural merger. Here, instead, they are saying parties first need to go and kind of apply for a antitrust approval and then come for, then the creditors will approve. Anybody who sat in a committee of creditors or in an IBC process will understand, how much uncertainty just this one aspect brings in sometimes. So things like this, and there are many such things, which we need to think through, put it together so that, it is then commercially actionable. Another point you touched upon, which is really, really relevant, is related subsidiary. So if there's one holding company, 2 wholly owned subsidiaries, even those today are not part of a fast track merger if those 3 have to merge. Leave aside a step down subsidiary and, those different commercial, which are very, very common aspects which are there. So all of these points really, really resonate with me at least and the kind of work that we do. Thank you.
Thank you so much, sir. I'll request Shavik sir to step in.
Right. Well, thank you. First of all, I would like to thank DAKSH for making this panel possible and also bringing some of the best minds in the form of Mr. Ahluwalia and Mr. Ananthashivan to weigh in on the entire issue. Now, there was a few questions which this panel was supposed to focus on, and I actually had my thoughts on each of that. And but before starting that, I would just quickly like to talk about a common point which emerged from both Mr. Ananthashivan's session as well as Mr. Ahluwalia's as pointers. It is that somewhere down the line we are starting to think that you ask anybody who has been part of a merger or who has been representing one of the parties, what exactly is the problem with the NCLT process? It's, of course, as Mr. Ahluwalia said, that to a certain extent, when you are an investor who's part of a merger, it's not a bad idea to have judicial body look into the nitty-gritties just to ensure that procedural fairness, everything is observed. That's fine. But you ask people the common problem with the NCLT process, only one response: delay, delay, and delay. So the issue is, of course, that's one of the reasons why they started thinking about taking NCLT out of the equation for at least some of the so-called fringe mergers, which do not cause a lot of threat to the system or whatever the case is. Now, there have been a lot more, or I would say, disruptive suggestions which have been made by people from the industry. Like some people are saying that, why do we even need to look into NCLT process at all? Just check whether something is in the public interest or not. If it is in the public interest, then let the other matters be sorted out between the shareholders and the creditors themselves, who are the stakeholders of this deal. If the creditors have an issue with the post mergers, well, there are other other kinds of options or recourses that they can have, because at least with regard to those mergers which are now being part of the fast track process itself, think about it, a WOS getting merged into a holding company. Well, the holding company at the end of the day controls the matter anyway, and overall they will continue to be liable for the debts of this. So these questions keep on arising at the same time, right? So to what extent do we include the NCLT? And if we don't include the NCLT, what is going to happen? What are the problems, if at all? Now, one very interesting point has been made by both the panelists before also in common, which was that in the absence of NCLT, the current process, say regulators like the regional director who are involved in this process, so how are they looking at their role? Because it's no use that if I take NCLT out of the equation and then I put in some regulators here who will take as much time, or even worse, they will not understand the exact mandate that they have under the current provisions. So I will just mention this one case which had come pretty recently, I would say. So what had happened in this case was that so the Asset Auto India Private Limited, I'm sure the other panelists and some of the participants would be aware of this. So the Bombay High Court gave this judgment wherein it had happened that after the regional director had looked into one of these processes, they just went ahead and said that, well, we don't think that this scheme is in the public interest, or they started looking into the valuation aspect, etc., etc. The end result was that the regional director completely sort of dismissed the scheme. Now, the problem is that neither Section 233 nor Rule 25 actually envisages such a role to be played by the RD at all. The wordings are fairly clear. So if the RD believes that there is a problem with this scheme, it's not in the public interest or whatever, they push it up to the NCLT for adjudication. But if the RD completely dismisses the scheme out of hand, then they are essentially acting themselves as a quasi-judicial authority, which they were never meant to be. So this is also probably, I mean, if you look into the psychology of things, maybe if you take the judiciary or quasi-judiciary out of a process and put some other people in the decision-making authority, at some level they start thinking that they themselves have a duty to act in that quasi-judiciary capacity, which they don't. I mean, that was not the purpose of the provisions at all. Well, so thankfully, Bombay High Court actually clarified this matter, but this is a one-off scenario wherein the court actually managed to look into this and come up with something which is fairly similar. Think about it. If these kind of decisions start to be taken in the fast track process and I have to go to the court anyway to solve this, then what problem did I have with the NCLT route? So these things will keep on happening till the point, I believe the issue is, of course, that can we actually look into the problems, real systemic problems that the NCLT process has right now? Because if we don't do that, then the only other option we have is, fine, some mergers are going to get cleared in this fast track route. That's great. But what about the others? It's not that they're any less important. In fact, many of them will be more important in the bigger scheme of things, right? So under such circumstances, so Mr. Anantshivan made a very interesting point that, if you look into the NCLT decisions which are being taken now, so I had an opportunity to be part of a research project where we had to look into 1 year's worth of NCLT orders throughout. And our job was to focus on the company law related, not IBC, but the other rest of the orders that the NCLT is making. So when we had started, we thought, well, we know that IBC matters get discussed a lot, but at least maybe 50% of the matters has to be related to company law issues, right? And there was an eye opener. Close, I think the exact number was between 65 to 70% of the orders which had been given by NCLT in that year were related to IBC matters alone. This, as Mr. Anantshivan rightly points out, makes this no longer a national company law tribunal, but more like a national insolvency board or national insolvency law tribunal. NCLT was never meant to do that. But of course, one of the reasons behind that can be the fact that a very strict timeline-based resolution of IBC matters, which ordinary company law matters, including these kind of M&A issues, never had. Now, the question, of course, is that if we can say that for certain kinds of mergers, we can get the process done within 2 months under the speedy route, fast track route, as is prescribed now. Then the issue comes to that why can't we have maybe not 2 months? Nobody expects all the mergers to be resolved in 2 months, but well, maybe a little bit more rational timeline, which makes sense, not 1 year, not 1.5 years, because we have to understand that when we have to announce the merger publicly, we have to come up with a lot of terms and conditions, including share exchange ratio and everything. So we announce that, and the actual thing can't take place 1.5 years, sooner than that. Then the terms and conditions, many of those terms and conditions start becoming obsolete because of changing market realities. We can't afford to wait for that. So we can raise this question, and I agree with both Surya and Vardaan that it's high time that we start this conversation that, the fast track merger route is, by all accounts, a good one, but it's not enough to simply say, well, this process is faulty, so let's take some of the mergers out of this process. The question is, how can we try to address the problems which are plaguing the process itself? Because NCLT is going to be there. Even if the RD believes that something is not in the public interest, then they will push the matter to NCLT, and then again it goes for 1 year, 1.5 years. So it's not that the NCLT is being completely kept out of the loop of this equation. And the other point that I would like to, for us all to think about is that even when we do come up with these kind of regulatory changes, that the CCI's role was something which was going to be part of the discussions. And as all of us would be aware of, even the CCI had tried fast tracking some of their merger review roles when they had introduced the green channel, that almost four years back, right? Now, if we look into the data, the green channel route has not been very popular. So I think back in 2021, approximately 28 to 29% of the merger filings before CCI had adopted the green channel route. But that number had come down to, I think, around 17 to 18% in 2024. So then the question comes that, well, if we have an expedited route, why are more and more companies not opting for that, or at least trying to check their eligibility under that particular route? Well, one of the possibilities can be that how do you interpret the provisions which are associated with these fast track mergers? You can't have very ambiguous provisions, because the more ambiguity you have, the greater is the chance that the regulator gets to interpret those. And often regulatory interpretation, as has already been mentioned, so it often does not have that necessary level of flexibility. So CCI has opted for as much literal interpretation of the green channel routes eligibility and all the processes as possible, to the extent that clearly the message has gone out to the industry. There is no use opting for this route. They're going to say no anyway. Let's go to the main route. Now, my worry is that, well, is this something similar to what is going to happen in Section 233 if the parties involved, like the official liquidator or the regional director, if they start interpreting it? Because, make no mistake, there is no dearth of ambiguity even in Section 233 and Rule 25. There are multiple things. Like, for example, in all these cases, if you look, the regional director, the case that I mentioned, there's a very cogent reason. The changes which took place in Section 233, allowing the regional director that kind of power and everything, all of that keeps on saying the regional director may send, may do this, may do that. The problem is that it's not, the regional director does not really have an option not to escalate it if they believe that there is a problem. They can't sit in judgment of that problem itself. So then there are issues like where it says that when the RD is going to look into public interest or the interest of the creditors. Question is surely not or. Question, I mean, the right conjunction should have been and. And I mean, it keeps on happening. There are multiple such issues involved in the drafting of the provisions themselves. The only point that I'm trying to make here is that, well, when those ambiguities are there and you put some authorities to decide their actions based on those provisions, then these kind of things will keep on happening. People are talking about risks. Well, global best practices, Singapore, Delaware, Canada, all of them, their own version of the fast track mergers, there is no requirement for separate, that much high threshold of creditor approval or shareholder approval at all. And here we have, and just the irony of things. On the one hand, we are saying that, well, these mergers are not that important or that problematic as will need NCLT involvement. On the other hand, we are saying that the creditor and shareholder threshold, wherein whose permission needs to be obtained, is much higher than the ordinary route, up to 90%. And as Mr. Amandashivan pointed out, this can lead to travesties. How am I going to get 90% people in a listed company to even appear for this kind of matters? So the issue is that if the option is to, if the objective is to actually go for smooth functioning of the events, then that rationality and that flexibility has to be introduced. And it's not only the legislature's job. Clearly, they will have a role to play. But the overall idea that we should focus upon is surely how to make the NCLT process more conducive to handling all kinds of mergers, and not only those mergers which qualify for the fast track route. Why can't all mergers be fast tracked? I mean, one bench, having separate bench about NCLT is probably a right step in the deal, but it's not going to be enough unless and until you populate the bench with the right set of people who will have some appreciation about the way the industry actually functions. Because, well, we were talking about the appointed date and things like that. Judiciary does not consider or perceive of these dates as to have the same significance as it does for two industry people, right? So because for them it's, well, one date after another date, it's only necessary that we take the decision in an informed manner and everything. But that's not always the reality. As has been stated here by the other panelists also, these deals are only the tip of the iceberg. The major transaction lies somewhere else. So if you make that tip of the iceberg so difficult to be seen or so difficult to be resolved, there will come a point of time when all the parties involved, all the stakeholders involved will say that, see, we forget about it. We don't want NCLT involvement in mergers at all. Just look at every merger for a public interest component, and if it is not there, just allow the creditors and shareholders to thrash it out. If they have any problem, well, they will take it to the OMN route and or the credit default route. There are other options. So that's the idea. Like, so we have to think about what are the areas, how do we attract the set of people who will be able to join NCLT and make a difference, who will be able to look at a problem from a solution-oriented perspective. Because if the focus is ease of doing business, trust me that, making certain exceptions to us for a very niche sort of mergers is not really a long-term solution. As has already been stated here, the affiliate subsidiary route has not been included in the fast track route, right? So, but there is no reason why not. I mean, it's as good as a thing as any. And there are other issues about whether we can do reverse mergers, demergers through these routes, etc. And these questions will keep on happening. You till the point we address the systemic imbalance, which is not allowing NCLT to function the way it was supposed to function with regard to the mergers. I believe that this is going to be a problem, which is why I believe that initiatives like this discussion or the project that DAKSH is proposing now is of paramount importance. I mean, more and more industry would probably end up supporting it over the days. Yeah, that's all from my side. Thank you.
Thank you so much, sir. Vardaan sir had to leave for an urgent call, so we have two panelists with us. The floor is now open for Q&A, and I request if any of the participants have any question, they can click on the raise hand icon and we'll unmute them. Okay. Go ahead, sir.
Thank you, Shavik and Murali sir. Very, very enlightening. I just want to push the conversation. Some ideas have come in already. Just want to push the conversation and push both of you on the solutioning. Making exceptions is not going to solve the root cause of the the problem, if we can call it that, or the situation. What else? What more do you think are this and the root causes of which need to be addressed for it to have a very systemic impact? I dedicated benches are a good step, and that the rules need to be more cognizant of commercial realities. But there's always this question of good rules versus good people following the rules. So the rules versus capacity to follow the rules, or people who follow the behavioral changes. Want to get both of your thoughts on some solutions to the problem of NCLT. Murali sir, you want to go first? Your screen is frozen.
I think his screen has
Screen is frozen. Yeah. Shavik, you want to go?
Well, I mean, personally speaking, I would love for more insight from the practitioners in this regard, because they are the ones who will have to go and face the NCLT on a day-to-day basis. But one thing comes to my mind is that, see, the idea is when you look into the real problems, because nobody is alleging the fact that NCLT is deliberately sitting on a matter when they can do it or things like that. It's a combination of multiple factors. It's a combination of resource constraint, I'm sure. But there is also the aspect of simply populating the NCLT with, say, 3x judges is not probably going to be the actual solutions for anything. The focus should be on that. What are, as you yourself had mentioned, that can we develop a kind of a checklist to a certain extent, because of not all of these matters have to be adjudicated ad nauseam. Many of these matters are certain things which you look into, see whether they are fulfilling certain criteria, and then you just pass them. There is, of course, the possibility of using technology to sort out many problems, as is now being considered across multiple jurisdictions. But there is also the over and above idea that maybe we can think of some kind of a guidelines or some kind of a handbook for the NCLT members who will actually be look into specific for merger related matters. These are the things which you can dispose of quickly. These are the best practices. These are how, these are the kind of regulators reports you should go by and do not look into. I mean, if there is a valuation report clearly which is given by an expert, what does NCLT propose to do with that second guessing that report. NCLT is not a valuation expert by any means whatsoever. So I think these things, a lot of people in NCLT who are currently handling the matters, I'm sure that they will themselves welcome such thing, because they don't want to, keep on trying to second guess in matters wherein they themselves know very well that they are not the experts of, right? So something to that level of looking into what exactly are the systemic problems can we come up with a similar kind of timeline, just like we're doing it for IBC or like we are doing it for the fast track mergers? Can we think of such a timeline for overall merger process? And of course, any timeline will have exceptions. The question will be that what about the really complicated stuff? Well, for really complicated stuff, you make extensions. That's fine. No timeline is as much as saying that, this has to be adhered to at the cost of everything. So a combination of maybe giving the right set of training or the right set of supporting resources to the NCLT members, as well as increasing the NCLT's capacity building, can be an option. And at the same time, the specific provisions, the rules, as I mentioned, even 233 and Rule 25 has got multiple ambiguities. So as on a separate level, that's something for the legislatures to solve. That's not something the tribunal can solve, right? So more and more, specific provisions can be made about commercial laws. It's the better, because at the end of the day, commercial laws do not need ambiguity for most provisions to work. There are always sufficient amount of residuary power given to all the tribunals that they can look into matters in the interest of justice for not to have that clause-specific ambiguities. I think a combination of both can be a good way to start. And of course, we need to have this conversation. I mean, I'm sure most of the industry people would be aligned with this. It's just that, lobbying is not a very good term, but at the very least, if a common consensus can be built around those, I think that can be useful. And now I will, I'll now gladly listen to what
Murli sir, were you able to get the question? I think we lost you for a bit at the point. We can't even see you now. Your video is off. Maybe there is a connectivity issue.
Yeah, I texted him. The messages are also not.
Sure.
Yeah. Okay. Shauvik, so meanwhile, I have a question. So, the NCLT solely cannot be blamed or held accountable for every inefficiencies. What is the role of the parent organization or the ministry concerned here? How can they pitch in to actually, and also everything cannot be fast tracked. Each merger cannot be fast tracked. There can be only certain categories of merger that can be fast tracked. So what is the role of concerned ministry here?
Well, I would say that some of the things that the ministry can do is, look into. I think there are two major points on which most of the NCLT delays keep on happening. One, of course, is this fairness reports. That's something on which from what I have been given to understand, there are also tax issues involved here. But the complaints and the fairness reports are the ones which end up often unfairly stalling mergers. So I think it can be considered that if there is a genuine legal dispute by, say, unsecured lenders, which is the reason why we have this high level of threshold conversation, right? So why not make the dispute resolution mechanism separately through the framework meant for credit defaults? Why is it that we have to have, say, 90% approval of the creditors? And why not make these affidavits more commonplace to accept? I mean, these are things which can certainly be done by the ministry, even within the current framework, they don't have to change the law or anything for this purpose. And the second part is, of course, as I said, the support or guidelines which has to be provided to the NCLT only has to come from the ministry. So they can and do so by way of the notifications. So, this is a handbook. These are certain guidelines. These are certain checklists. Use this and also try to come up with some kind of rationalized timeline for the entire thing. Because currently, in the absence of timelines, as we have said, we have IBC, we have merger approval. One is operating on a timeline, one is not. So it's obvious that the one which is operating on timeline will be prioritized by the people. So if you want to have proper resolution of disputes, then you will have to have timelines for both of these situations, at least comparable timelines depending on the factors. So these are matters in which MCA can certainly play a role. We are thinking that post-budget, there have been some talks about what kind of reforms are exactly going to take place. The government does want to come up with reforms. We don't know what. But simply getting, as I mentioned, simply getting more and more mergers outside the NCLT purview will not also make sense, because even as Vardaan mentioned, some of the investors may actually prefer at least a quasi-judicial body to look into the matters upfront, just to see that there is no, later on nothing ends up completely sabotaging the deal or something like that, right? So yeah, that's, I think Mr. Anand Sivan is now online, so he will be in a better position to talk about it.
Yeah, I did hear you, Surya, on this. How could we make it more effective? Yeah, we can't simply wish it away. Having said that, of course, there is this talk of having a dedicated bench for NCLT. We've been making these representations, but if it happens, again, that is twofold. One is we should have a dedicated bench for exclusively for company matters, divorced from IBC. That is number one. Number two, the selection of members themselves. Okay, I mean, for whatever reason, the pattern has become, of course, you need a judicial member and a technical member. For whatever reason, the more and more of these technical members are all retired chief commissioners of income tax. I mean, but we don't have anyone on the table. I mean, when we go stand before them, neither of them have any expertise in company law or having dealt with mergers. Of course, the income tax commissioners would have dealt with that from a tax scenario and all that, but not on the law involved. I mean, it is learning process for them. So unless they come up with something, talk about a bench exclusively of company law, of constituting members who have their skill sets, but then they'll turn around and say, unless somebody else, I cannot consider them. I mean, people having experience and skill sets, this is not going to improve. It'll kind of, but it is going by the
We can see you, sir.
Yeah.
We can't hear you, but we can see you.
I'm back. I can be heard. Yeah.
We can see you and hear you now.
I don't know. You can see me and hear me?
Yeah.
Some.
Thank you so much.
So,
I was hoping the panelists would raise that issue on the composition of the bench. We are seeing this across tribunals, except probably in the income tax appellate tribunal, that the purpose of the tribunal was to bring in an expert along with the judicial member.
Yes.
Yeah, there seems to be some lag.
The technical member was supposed to be somebody who assists the judicial member in technical matters.
Correct.
So the presumption in these
Seems to be some lag here. I think the concern across the board to whomever we have spoken to in the last few months of our engagement on this topic has been the quality of the benches.
Basically, it boils down. So it is a daily challenge we are facing, but we can make that many representations, and this is, I mean, we are still hoping for the best. This is where we are.
Yeah.
And with their short tenure transfers, there is no stability, longevity. I mean, we had multiple benches. The new bench comes and says we are on hand. They're thinking out of the boxes, move all these forward. They are doing a good job. They've been trained to deal with IP matters, commercial matters. But then this is, that would be utopia, or it's a little far-fetched thinking. That's not going to happen, for which you need to amend the act itself. But let us hope dedicated company benches with members with the required skill sets, if they are in place. As a body, I mean, a small association from from the trade bodies and associations, it has to have to do. Maybe they are doing a decent job of ABC is concerned, but then these are a couple of things I can think of on the CRF stage. Yeah.
Thank you, sir. Ritima, back to you.
Thank you, everyone. We have been joined by Harish Navasappa, sir is a senior advocate and also co-founder at DAKSH. Over to you, sir.
Yes, first of all, apologies for I had to drop out in the middle because I lost internet connection, but I heard most of the comments and conversations. So I really have only 2 points to make. That is, I feel quite strongly that there's no need for a mandatory approval like we have in India currently for amalgamations and mergers, except where there are lots of public money involved. For example, if two insurance companies are merging, or if there are, say, NBFCs or banks that hold a lot of public money and then they are merging or amalgamating, then I feel some regulatory supervision by way of a mandatory NCLT process is relevant. Otherwise, I actually fail to see the reasoning as to why we insist that in a merger situation or a demerger situation, we need a statutory approval process. And I know, today we have spoken about, I noted Vardaan's comment that, there may be comfort that instead of a fast track approval, which is only at the RD level, NCLT getting involved gives some amount of comfort to the parties involved. I mean, I actually, said I have a different opinion on that, and I think we need to question that. See, if it's just a share purchase and merger through a share purchase where one entity buys 100% shares of the another entity, that is also a merger. What is it that is different? The only thing that is different is one company is not being erased from the books. So just because we have made a process whereby winding down a company and erasing it from the register of the companies is so difficult, we can't reverse engineer the process and say, therefore, we need a NCLT approval for it. I think we need to take a step back and see what is it that we are really seeking to supervise, or what kind of regulatory, oversight do we want over business in terms of mergers and acquisitions, in terms of amalgamations, demergers, etc. And I know this is I'm trying to take this discussion in another direction, but we will leave it for another day. But I thought, as since you asked me to give closing remarks, and in terms of process, Murli and Vardaan and Dr. So have already said everything that there is to be said, and the inefficiency of the process, the struggles and utopia, as Murli said, all those are there. But I feel the same comparison was made that why can't we compare ourselves to regulatory regimes in other jurisdictions? And it's not as if a merger in India or an amalgamation in India is unique and different from what happens in the in comparable jurisdictions like UK or the US or other European countries. And I think anyway we have a heavy regulatory state that is struggling to meet the burdens of burdens placed on it. So why add more, right? I think the key should be to reduce it. And if we are okay with the situation where one company buys out the shares of another company, and essentially it's a merger, and we are okay with no regulatory approval, why do we need this long-winded process for writing a company off the books? What are you achieving? Are you trying to protect the taxmen? Are you trying to protect the creditors? Are you trying to protect, licensee, the license? I mean, what are you really trying to protect? I think we have lost sight of that. And unless we have a discussion on what this entire process seeks to do and what do we want from this process, I think this confusion will continue. The problems of the time and interference that you give any bureaucracy or regulator a power, they will obviously try to exercise it. They won't restrain themselves. That comes from a very high level of maturity, which not all regulators or all personnel involved may not have. Therefore, while this panel discussion has been wonderful in terms of the existing regime, and we need to, what steps we need to take to improve the current processes, I would also urge everybody, since we are looking at policy reform, and the government seems to have initiated this in the budget speech, I think we should try and tell them, listen, go the full hog, limit the requirement of approvals only to sectors that are really essential, where public money is involved. In other cases, there's no need for this. So I won't, say more. I think, on a Saturday morning, I'm happy to see such a lively discussion. And congratulations to everyone involved in having this discussion.
Thank you. Thank you, everyone, for joining us. If there are no more questions, we can wind up the session. This is the last call for questions. Okay. Thank you. Thank you, everyone, for joining on Saturday morning and giving some time and knowledge. Goodbye. Have a great day.